Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law and probate attorney in New York. Today's topic, I fielded a question about a will and a deed. It's a rather typical scenario. The inquiry came from an attorney colleague of mine that asked me, really the question was what I would charge for a will, and presented me the scenario a little bit. So the circumstances are that siblings own a property, and one of the siblings, it's actually 4 siblings own a property. One of the siblings want to have a will, and upon their death, have their portion of the property, go to family members or something. I don't know yet exactly. So this is how I fielded the call. I said, the controlling document for a property is the deed. So my first line of inquiry is, who's on the deed, and in what way are they entitled? So if it's a joint tenancy, now, siblings really most frequently do not own property jointly, but sometimes they do. So if they're tenants in common, if they own it in that way, then any of the 4 siblings could pass their property on to either their heirs or beneficiaries in a will. So that's the first level of inquiry, and I asked for the property address. The property is in New York City. New York City deeds we're able to look up. Got the property address, looked it up, saw that it's tenants in common. I took a photo of the deed with my camera. I texted it to my attorney colleague and said, tenants in common, I can do a will. The will can pass that property, that respective share, that interest, onto a beneficiary named in the will. So, not case closed, case solved, but case begun. So, that's it. If you'd like to speak with me, if you want to reach out to me, go to frankbrunolaw.com.